Hello and a very warm welcome to latest case analysis series by Law Seekho. This is Monica Rahar, and for today's discussion, we have taken up a decision by the Allahabad High Court, which is dated 21st of October 2020. The name of the case is Neelam versus Ram Asre. It is a single judge bench decision, and the bench consisted of Honorable Justice Vivek Agarwal. Now let's proceed and understand the issues of law. The first issue being whether a court can direct a wife either to undergo or not to undergo a DNA test in a divorce petition on ground of adultery under Section 13 of the Hindu Marriage Act. Second being whether the results of a DNA test can be taken as conclusive proof of allegations which are leveled by parties seeking such a test. And the third issue being whether a DNA report is just a piece of expert evidence or is it a conclusive or a substantive piece of evidence to raise a presumption against a wife. Now let's proceed and understand the brief facts of the matter. In the year 2004, both the parties, which is the petitioner and the respondent, petitioner is the wife while respondent is the husband. So the wife and husband, they got married in the year 2004 and three daughters were born out of this wedlock. In the year 2013, both the parties started living separately, and as per the husband, there was no resumption of cohabitation between them since the year 2013. The wife, however, has rebutted this submission of the husband. In the year 2014, the respondent, which is the husband, had given customary divorce to the petitioner and he started paying maintenance to her since then. However, in the year 2016, a male child was born to the petitioner at her paternal house, and after the birth of such a male child, the husband filed for divorce before the family court Hamirpur on ground of adultery, and he also filed an application to direct the wife to undergo a DNA test in order to ascertain the paternity of the child. In the year 2018, the family court, in response to this divorce petition of the husband, allowed the DNA test, and while giving such a permission for the DNA test, the family court cited these two decisions of the Honorable Supreme Court, which is Dipanvita Roy and the second being Nandlal Vasudeo. We'll be discussing these decisions later on as we proceed further. So the family court allowed the DNA test. The wife, aggrieved by such a permission given by the family court, she challenged the family court decision in the High Court of Allahabad. And the contentions which were advanced or raised by the counsel for the wife, these were threefold. The first being she denied the allegation leveled by the husband that there was no cohabitation between these two parties since 2013. She rather contended that there, in fact, was cohabitation between these two parties. And then she had to leave her husband's house and she had to reside with her parents due to harassment that the husband gave her while she was pregnant with this boy. And then she raised a plea of presumption under Section 112 of the Indian Evidence Act. So, before we proceed, now let's have an understanding of what is provided for under Section 112. So it provides for birth during marriage, conclusive proof of legitimacy. The fact that any person was born during the continuation of a valid marriage between his mother and any man or within 280 days after its dissolution, the mother remaining unmarried, shall be conclusive proof that he is the legitimate son of that man unless it can be shown that the parties to the marriage had no access to each other at any time when he could have been begotten or conceived. Now let's proceed and understand the reasoning and decision of the court. So the High Court reiterated the two Supreme Court decisions which the family court also relied upon. So the first being the case of Dipanvita Roy. So in this case, the Supreme Court had held the following, that husband filed for divorce on the ground of adultery. The adulterer was named and the husband filed for DNA test of himself and the male child which is born to the wife. The family court, however, unlike in this decision, dismissed the petition of the husband. The High Court, however, on being approached by the aggrieved person, reversed this order and the High Court allowed the DNA test. The Supreme Court also upheld this decision in the High Court, and the Supreme Court rejected wife's contention that she had access to the husband. Now, in the second case, which is the case of Nandalal Vasudeo, in this particular case, with respect to the DNA test, the Supreme Court had held that DNA test is an accurate test, and on that basis, it is clear that the appellant is not the biological father of the girl child, and the result of a DNA test is said to be scientifically accurate. This is the observation of the Supreme Court, that a DNA test is said to be scientifically accurate. Now, with respect to the presumption under Section 112 of the Indian Evidence Act, it was noted by the court that Section 112, it raises a presumption of conclusive proof on satisfaction of conditions which are enumerated therein, and such a presumption, it is also rebuttable. The presumption, it may afford legitimate means of arriving at affirmed legal conclusion while truth or fact is shown is known. So when truth and fact is known, there is no need or there is no room for any presumption, and where evidence to the contrary is available, then the presumption is rebuttable. So that is to say, there has to be a presumption by virtue of section 112. However, if there is any concrete proof available contrary to such a presumption, then that the presumption is rebuttable. In the interest of justice, the interest of justice is best served by ascertaining the truth, and the court should be furnished with best available science and may not be left to bank upon presumptions unless science has no answer to facts in issue. Now, with respect to the conflict between a conclusive proof, the court stated that in case of conflict between conclusive proof and proof based on scientific advancement, which is accepted by the world community at large to be correct, the latter should prevail. That is, when we are to choose between conclusive proof and also proof which is based on scientific advancement, in such an advancement, it is accepted largely by the world community to be true, then the proof which is based on scientific advancement, it should prevail. Next, proceeding further, the court also drew differences between legal fiction and also presumption of fact. Now, with respect to legal fiction, the court stated that former, which is legal fiction, it assumes existence of a fact which may not really exist, while presumption of fact, it assumes existence of a fact which depends on satisfaction of certain circumstances, and those circumstances on the satisfaction of which such a fact depends, these circumstances logically would lead to the fact sought to be presumed. Section 112 of the Indian Evidence Act does not create a legal fiction, but it provides for presumption, and such a presumption, it should be based or it should depend on satisfaction of certain circumstances. Now, with respect to the fact that whether a husband or can a husband who is not found to be the father of the child so born be forced to raise the child, the court noted that the husband's plea of non access to wife when child was begotten or conceived stands proved by DNA test report, and the appellant cannot be forced to bear fatherhood of child when scientific reports prove contrary. An innocent child may not be left to be considered as a bastard, as the marriage between her mother and the father was subsisting during her birth, but in view of DNA test reports, consequences cannot be forestalled. And then the court stated that truth cannot be defied, truth must triumph. This is, in fact, the hallmark of justice. And the proof, which is based on DNA test, it would be sufficient to dislodge a presumption under Section 112 of the Indian Evidence Act. So these were the findings which were noted by the Honorable Supreme Court in the case of Nandalal Vasudeo, and the Honorable High Court of Allahabad placed reliance on these two cases, which I also mentioned above, and then the court made its own submission. So the High Court stated that even the Supreme Court approved a DNA test and the validity of it as the most legitimate and scientifically perfect means using which the husband could establish his assertion of infidelity. This should simultaneously be taken as the most authentic, rightful, and correct means, also with the why for her to rebut the assertions or the allegations which are made by the respondent husband, and to establish that she had not been unfaithful or adulterous or disloyal. And therefore, in terms of the law laid down by the Honorable Apex Court, the Allahabad High Court stated or held that no illegality, infirmity, or arbitrariness is found in the decision of the family court, and there is no reason for the High Court to interfere it with. So, therefore, essentially, by this particular order, the High Court gave validity or upheld the decision of the family court, which allowed the DNA test in terms of the fact that Supreme Court had itself laid down that DNA test is the most legitimate and scientifically perfect means using which either the husband or the wife both can substantiate their claim either of infidelity or of not being an adulterous partner in the marriage. So that's all we have for this entire case analysis. At the end of it, you may find a list of abbreviations which we have used in the note. Thank you for being with us.